So we have some time for question before we'll ask Steve for reaction.
Okay. I'll be brief because I'd like to get comments from the assembled group here. But I'll just say a couple things very quickly. First, George and I actually agree with each other about a very important point he made, which is there has to be positive evidence of wrongdoing in order for there to be legal action taken against a firm. That is a very different statement than is often made in this debate, in which, because it's assumed that because something is possible in theory, it must be happening in practice, and therefore the burden of proof on the firm is to show that it is, quote, not engaging in holdup. I raise this because my initial training is actually as an historian, and one of the things I learned in history is that up until the 17th century, when you were accused of being a witch, the burden of proof was on you to prove you're not a witch. We've moved beyond that since the Enlightenment. The second point I would make is that it's important to keep in mind differences in definitions between patents conferring market power and holdup. So when George was referring to the Sherman Antitrust Act and U.S. Steel and the amount of steel going up and the prices falling, nobody accused U.S. Steel of holdup. U.S. Steel was accused of the exercise of market power. These are different claims, and they have different mechanics. I'd further point out that the U.S. government's case against U.S. Steel failed. And it failed because prices were falling, not rising. It's not illegal in U.S. law to have a monopoly. It's against U.S. law to have a monopoly that exists in restraint of trade that harms consumers. If, in fact, we really believed it was monopolies that were bad, the DOJ ought to be investigating Intel. One last point, and that's about whether or not there's entry. One of the points that was made by George in the case against U.S. Steel was, well, there isn't entry. In the smartphone industry, we see tremendous amounts of entry. It suggests that the exercise of market power by use of patents can't be very strong here. That isn't to say it never happens. So here's where I agree with George. I'm sure that it happens. I'm sure there are firms that behave strategically. But that's a question about individual cases where the burden of proof is on the claimant that a firm has acted badly. We shouldn't presume wrongdoing. Finally, there's this issue of the counterfactual. And this comes up over and over and again in this, well, there's a counterfactual world in which things could be better. You know, it's like, yeah, there's a counterfactual world in which I could have won the Tour de France. I just didn't have the right drugs. We can operationalize counterfactuals. The whole point of econometrics is to operationalize the counterfactual world. So I'll just invite you to do the following simple thought experiment. Take the royalty stacking literature at its face. If there are 130 standard essential patent owners in the smartphone ecosystem, and you believe the formula, then what the counterfactual is that we should have roughly 15 times more smartphones produced today at a lower cost than today. Well, there's 1.8 billion smartphones sold in the market today. 15 times 1.8 billion let's round it around to about 25 billion. So the counterfactual is that every man, woman, and child between Kinshasa and the North Pole should be buying 4 smartphones a year if there's no royalty stacking.
Thank you. We will take some questions from the audience. Yeah.
Keith Mallinson, a question for you, Stephen. On the stacking side, the way you described it, it seems to be an all or nothing phenomenon. Either stacking exists and the market blows up and you get all these bad effects, including no technological advance, no market entry or whatever, or alternatively, there is no stacking and you have a healthy market. On the basis that we don't have the market explosion with smartphones, for example, we still have some kind of cumulative royalty, which I guess on the basis of your explanation is not a stack, it's just a cumulative royalty. Does that, on the basis of your analysis, does that then mean that that cumulative royalty, whatever it is, on average, is necessarily then fair and reasonable? Is that a reasonable royalty? Can we jump to that conclusion? Or could that aggregate royalty still be excessive in some kind of way?
Short answer.
So the mathematics of this are straightforward. What's happening is if you have reasonable royalties, they're adding to the value of the phone, right? They're adding to the value of the device, which is to say it increases consumers' willingness to pay because it's a better device, right? My iPhone, which is sitting over there, is a very different device than the original Dynatech produced in the 1990s. We can all agree on that. And it's because there's all these patents and standards that are embedded in that phone. So what happens is the demand curve is shifting out because willingness to pay is shifting out. If you have unreasonable royalties, right, if they're not FRAND, what you're suggesting then is that there is a stack that's accumulating over every patent holder, such that you've got to be moving up the demand curve, such that if it is the case that there are systematic, and I want to underline the word systematic, unreasonable royalties being charged, then you are going to get the result of the collapse of the market. This isn't to say that there's never someone that owns the patent that tries to charge an unreasonable, non-FRAND royalty, but it is to say that in aggregate, on average, what you're observing is a world in which the royalties are commensurate with the improvements in the quality of the device.
So that's a yes.
You can take that.
Reaction, Jorge?
There we go. Just to make a quick observation to that point. And I think the data shows that the majority of that 130 patent holders are not charging any royalty, right? I mean, the royalty chargers in the telecom market, as you know, are a few companies that are principal patent holders, right? There are lots of other companies, even large companies who hold patents who don't charge in the wireless telecom market. And there have been various theories about why that is. Some are cross-licensed with other players, so their cost and their revenue comes in patent trades rather than direct revenue from their patents. Others don't have enough patents to make it worthwhile. You see this in the case of IPXI, which tried to pull together a bunch of miscellaneous smaller patent holders and pool their resources together and create a trading market in 802.11. It didn't work. Those patent holders weren't doing anything with their patents really anyway, and they're not today, right? They didn't. That operation failed. The patent holders didn't show up and say, okay, well now, we're going to go start to charge royalties on these patents. So I think this is a tip of the iceberg situation, right? There are lots of patent holders who are not active yet, and I think part of the concern with stacking is that as patents are increasingly monetized, as those standards essential patents fall into hands of patent monetizers, there will be increasing royalties, particularly charged by entities who aren't in the game, who aren't selling products, and whose only motivation is making royalties. And, you know, we've seen in studies that I and colleagues have been doing on assertion of SEPs by non-practicing entities that number is getting pretty significant. And so, you know, I think it's something that should be at least looked at with caution in the future, even if stacking is not having a significant market effect today.
Okay, last question.
Thank you. I'm here, sorry. I'd like to address my question to Professor Laroche. I hope I pronounced that well. Do you think in European law there is a different solution than competition law to this kind of questions? And do you think that the German judgments now that are now discussed following the judgment of the European Court of Justice do still look too much to the preferences of the patent holder rather than to the other parties? Thank you.
So I think on the first question, yes, these are disputes that could be handled in contract law or IP law. And you see the asymmetry in that if you want to challenge the actions of the implementer, there's no way the implementer could be abusing a dominant position and so on. So you see that competition law looks at the two sides, it induces a disparity between the two sides in the discussion. So you would expect these disputes to be addressable also under the mechanisms of intellectual property law. So that would be, and then as for the German courts, I cannot say at this moment, and I wouldn't say that Orange Book was too SCP friendly, but it relied on a different set of assumptions. It assumed that the starting point was that when the SCP holder wants to use an injunction, it's because there's a runaway implementer, an implementer who doesn't want to negotiate. If that's the state of the world, then the German position is correct. If the state of the world is that typically these disputes arise rather when the SCP holder is trying to hold up, then the European approach or the Commission's approach is more correct, and I believe the evidence points rather to runaway rather than hold up being the dominant problem.
Thank you. So time is running fast, so I will conclude the panel. Thanks to all the speakers for these very nice talks and their very interesting view on the patent holder problem. Now I invite the member of the second panel to come to the floor, and thanks to